Thank you very much. It's a great pleasure to be here this morning in the beautiful Savannah area on beautiful Skidaway Island in this beautiful room looking at all these beautiful faces bright and early this morning. I'd like to introduce to you my colleague who's the most overqualified person in the room this morning for the job she's doing. This is Catherine Wanamaker. Catherine is a native of Orangeburg, South Carolina. She's a graduate of Hollins College. She has a master's degree in zoology from NC State. Is a graduate of Stanford Law School. She spent several years in the environmental litigation section of the United States Department of Justice before she joined the Southern Environmental Law Center last January, and Catherine leads our Georgia coastal litigation team. So, Catherine, we're glad to have you here this morning, even though you're just pressing buttons. So you add a lot more than that. As Tom said, I was a lawyer in private practice in Atlanta for 29 years. I was a partner in a small firm. I started and ended my private law career there. I fell into the practice of environmental law in the 1970s before it was even a field of practice. I decided that I liked it, that it was a worthwhile pursuit. So in order to build a career, I began telling people that I was an environmental lawyer. One thing led to the next, and that's what I did over the course of my private law career, handling all sorts of environmental cases involving protection of the air, land, and water. Among the cases I handled was the Clean Water Act suit against the city of Atlanta that led to the city's $2 billion program to repair and bring its sewage treatment system into compliance with our nation's clean water laws. My job at the Southern Environmental Law Center is therefore a second career for me. The Southern Environmental Law Center is an organization that was begun in 1986 by a fellow named Rick Middleton. Rick is a native of Birmingham, Alabama. He's a graduate of the University of Virginia and Yale Law School. After practicing law for about 20 years, he decided that he wanted to form an environmental advocacy organization devoted solely to protection of the South and its resources. So in 1986, he moved with his wife and then two very small children to Charlottesville, Virginia, and began the Southern Environmental Law Center from scratch. From that humble beginning, we have expanded to an organization that works in 6 southern states: Virginia, Tennessee, North Carolina, South Carolina, Georgia, and Alabama. We have about 40 lawyers. We have about 70 employees total. Our principal office, our headquarters office, is in Charlottesville, Virginia. We have a major office in Chapel Hill, North Carolina, a major office in Atlanta, smaller offices in Charleston, Asheville, Washington, D.C., and we're about to open up an office in Birmingham within the next year or two. We work in several different areas. We work in air protection, water protection, forest protection, what we call land and community, which is basically land use, coast and wetlands protection, and what we call protection of special places that we treasure in the South. We are a nonprofit, donor-supported 501c3 organization. We do not accept fees for our services. We never charge fees for our services. We are not for hire. We never sue for money. We never sue for private gain. Our job is to protect the public's interest in the public's resources in the South. We work at all levels of government, local, state, and federal. We work in all branches of government: the legislative, the executive branch, the regulatory agencies, and the judicial branch. Most of our work is collaborative work, where we work with local groups, local government agencies, counties and cities, state agencies, state legislatures, as they develop laws, regulations, and policies to protect our environmental resources. Sometimes collaborative work doesn't get the job done. And when it's necessary to litigate, we do. Our cases 99.9% of our cases, at the root of the case is an effort to get some agency of the state or federal government to enforce existing law. A typical example would be where an agency has some duty to require certain protective measures in order to issue some sort of environmental permit, and where those protective measures are not required, we might challenge the government's issuance of that particular permit. As I said, the cases are never for private gain, they're never for money. They're all strategically selected cases that are intended to make a specific legal point that can be used as precedent in cases going forward. Catherine Wanamaker has led our efforts in 2 of those cases down here on the coast just within the last year. One was, excuse me, one involved the state's permitting of a gigantic septic system to support 18 houses on a marsh hammock that did not meet any of the requirements of state law for septic systems. Under Catherine's efforts, we represented some river groups who challenged the issuance of this septic permit, and lo and behold, the state, after examining more closely the facts after the permit had been issued, said, you know what, this permit doesn't comply with the law, we shouldn't have issued it, we retract it. Catherine's led our efforts in another case involving abuse of what's called the silviculture exemption of the Federal Clean Water Act. The Federal Clean Water Act is an act that protects the nation's wetlands. We do not have any state law protecting wetlands in Georgia, so we depend on protections of the Federal Clean Water Act. Now, this is oversimplified, but basically the Federal Clean Water Act says that you cannot dredge and fill a wetland without a permit to do so. And in order to get a permit to dredge and fill a wetland, you must demonstrate that you really need to do it. There's no reasonable alternative. You can't engage in your activity somewhere else, and you're going to mitigate for the damage done. There are certain activities, though, that are literally exempt from the permitting requirements of the Clean Water Act. Those activities include what's called silviculture. Now, the first time I ever heard the word silviculture, I thought it had to do with insects like silverfish. But in fact, silviculture, S-I-L-V-A-C-U-L-T-U-R-E, means forestry. If you are a forester engaged in a bona fide forestry activity where you plant trees, you cultivate the trees, you harvest the trees, you replant the trees, you do not have to get a permit from the federal government in order to take your equipment in and to temporarily dredge or fill wetlands as part of your tree planting, harvesting, and cultivation process. That's fair enough. What some developers have figured out is that the silviculture exemption also creates a loophole for those who don't feel bound by to honor the law. What we've seen down here on the coast in a number of instances are developers buying timbered tracts for subdivision development, sending their equipment in to put the infrastructure in place, cutting the trees, filling the wetlands, building the infrastructure roads, putting in the sewer system without a permit. Then when confronted with their activity, they say, oh, we cut some trees, we're engaged in silviculture activities, and we're exempt from the Clean Water Act.